Welcome to this video on how the Board of Immigration Appeals works and how to successfully appeal your case. This is a practical guide to the Executive Office for Immigration Review's appellate system. The BIA appellate process is paper-based, reviewing only legal errors from the record of proceedings. The standards of review include de novo for law and the clearly erroneous standard for facts. Your brief is your most important tool, so you must ground all assertions in the administrative record and cite relevant precedent. The BIA is the highest administrative body for interpreting and applying immigration law. It operates within the Department of Justice and reviews decisions from local immigration judges and some DHS officers. The BIA's scope of authority includes appeals of removal orders, bond decisions, motions to reopen or reconsider, certain DHS decisions, and country conditions-based relief reviews. It is critical to remember what the BIA does not do. It will not hold trials, hear live witness testimony, conduct new fact-finding, or provide attorneys. The BIA is fundamentally a paper-based appellate court. Appeals are triggered when the immigration judge denies relief, issues a removal order, makes an unfavorable bond decision, or when DHS appeals a grant of relief. The 30-day rule requires strict compliance for BIA appellate jurisdiction. You must file Form EOIR 26, pay the fee or request a waiver, and submit it all within 30 days of the immigration judge's decision. There are absolutely no extensions or exceptions. Essential components of a BIA appeal filing include the notice of appeal, a clear explanation of legal errors, identification of issues for review, and proof of service to DHS. The Record of Proceedings, or ROP, is the official basis for BIA appellate review. The BIA reviews hearing transcripts, exhibits, the immigration judge's decision, and motions. No new evidence is allowed unless it is part of a motion to remand. The standard of review is crucial. Questions of law are reviewed de novo. Findings of fact require a clearly erroneous standard, and discretionary decisions are reviewed for abuse of discretion. Understanding these thresholds is key to winning. A strong BIA brief must identify legal errors, cite statutes, regulations, and precedent, and use clear, organized arguments. It must avoid emotional appeals and focus strictly on the immigration judge's mistakes, not new facts. Motions to remand are a special procedural vehicle for introducing post-trial evidence. They are filed when new evidence becomes available, circumstances change significantly, or ineffective assistance of counsel occurred. You must meet strict legal requirements to file this motion. Common grounds for appeal include the immigration judge applying the wrong legal standard, ignoring evidence, making improper credibility findings, failing to consider country conditions, or procedural errors. Motions to reopen are filed after a BIA decision to re-examine the case, typically when new, previously unavailable evidence exists, country conditions have changed significantly, or ineffective assistance of counsel occurred. These must be filed within 90 days, with exceptions. Motions to reconsider challenge the BIA's interpretation of the existing record. They are filed when the BIA made a legal or factual error, and importantly, no new evidence is introduced. This motion must be filed within 30 days. BIA decisions follow a hierarchy. An affirmance without opinion is the most streamlined, signifying the IJ decision is correct without further detail. Single-member decisions handle routine matters, and three-member panel decisions establish precedent and address complex legal issues. If you lose at the BIA, you may appeal to the Federal Circuit Court of Appeals. You must file a petition for review within 30 days. Remember, federal courts only review legal issues, not facts. For a successful appeal, build a clean record at the IJ level and preserve issues for appeal. Focus strictly on legal errors, cite binding precedent, and use clear, concise writing in your filings. Understanding the BIA is vital because its decisions affect criminal, family, and civil cases. Many clients face serious removal risks, and the BIA ultimately shapes national immigration law. To win at the BIA, you need mastery of the record, a full understanding of review standards, strategic issue selection, and strong legal writing. As is often said, the BIA is not a second trial. It is a legal battlefield, and preparation is everything. To avoid fatal mistakes, do not introduce new facts unless part of a motion to remand. Never attack the judge personally, and do not submit disorganized arguments. Crucially, never miss deadlines and always provide proof of service to DHS. Thank you for watching this video on the BIA appeals process, brought to you by the Legal Studies Division of the World Affairs Council of Austin.